Good morning, everyone. Thank you for coming along to another one of our One Chancery Lane webinars. And this time on Prager and Friends, we have got Matt Gatenby with us from Travlaw, which is, as the name suggests, a specialist travel firm. So a firm of solicitors that represents almost exclusively travel-related companies. So often defendants in personal injury cases, but also commercial litigation, terms and conditions, and that kind of stuff. But what we're going to talk about today is relevant for everyone because it's one of our soft skills webinars. Those of you who came along to the How to Get the Most Out of Your Barrister webinar a few weeks ago will recognise the format. Chris Deacon and I talked then about really teamwork was the thing we were talking about, and that's the best way to get the most out of your barrister. Today, Matt and I are going to talk about how to get the most out of your client. And when we were talking about this with other members of the firm and chambers and talking about it together, we really thought that the catchword for today is going to be communication. So if you take one thing away from today, it's that communicate with the client. But we've got a few little, I hope, useful tips, a few little stories to tell. But as always, there's quite a lot of you attending. You've got a massive range of experience. Some of you are clients, some of you are solicitors, some of you are barristers. Some of you are students. Please get involved and tell us what you think. If we're saying something that you disagree with, tell us. If you think that you've got something to add to what we're talking about, then also tell us. You'll see in the buttons at the bottom of your screen that you've got a range of options. If you raise your hand, I don't know what to do with you. So don't bother raising your hand because nothing will happen. If you feel that you want to talk to us, then there are the chat or the Q&A options. The chat option is for when you're just sort of saying hello and greeting old friends kind of thing. The Q&A option is for when you've got a question that you would like us to answer. Raise any questions you may have as we go through. There'll be time at the end, I hope, to raise some questions at the end. But I always find that if I save all my questions to the end, I usually forget one or two of them. So it helps us to answer your questions if you ask us as we go through, and we will pause as we go through, look at the questions that you're asking or just comments that you may be making on what we're saying. No problem at all. Again, those of you who know or who've been to our webinars before will know that we are recording this and it will be on our YouTube channel. So if you want to ask questions anonymously, that's fine. If you don't ask anonymously, then you may be named and be out there forever as the person who asked that question. But as we always say, there are no stupid questions. We've actually had some really interesting and quite challenging questions in the run-up to the webinar. So we've got a Darius question this time, which is great because we missed out on those the last couple of times. And as we go through, we're going to attempt to answer them. If you feel that we've not answered your question as we go through, then just mop it up at the end and we'll talk about it at the end. So Matt's in charge today of PowerPoint because mine doesn't work. So my lovely assistant will be moving the PowerPoint on. And the first thing that we're going to talk about is a question that we were asked. This is a Darius question. Is a question that we were asked that's actually really interesting. Before we even get to how to get the most out of your clients, we need to think about who is the client. And the answer is different for solicitors and for barristers. And that's really important for a number of reasons. So barristers have two clients. We have the lay client and the professional client. So if I'm working for Matt, he is my client, he is my professional client, but I also work for On the Beach or whoever it may be, whatever the tour operator may be, and they are my lay clients. I owe duties to both of those, and sometimes those duties will appear not to be consistent with each other. For example, this could never happen, but if Matt made a mistake, I would owe a duty to tell the lay client that he's made a mistake and advise the lay client that they should seek alternative legal advice. That is one of the most difficult things a barrister will ever have to do, but it is our duty to do it. There's no way of getting around it. There's no nice way of doing it. You just have to go into total professional mode and say to the professional client, I'm going to have to advise the lay client, I'm afraid. Everyone makes mistakes, but I'm going to have to tell the lay client that this is something that shouldn't have happened. the professional client, if they are professional, ought to be understanding about that, because that's just something we've got to do. And the lay client then needs to be told. So our primary duty is to the courts, which means that if Matt asks me to do something like destroy a document, I'm not allowed to do it because I owe duty to the court. Our secondary duty is the lay client, and then Matt is the least important of the moving parts as far as I'm concerned. I don't know why I'm personalising it in this way, Matt. Poor Matt sitting there being accused of making mistakes.
I know my place. It's fine.
I hasten to add, I have never actually had to advise that a lay client takes alternative legal advice from Matt, but I have had to advise that the lay client takes alternative legal advice from some professional clients, and it is very difficult.
We have the same obligation, of course. Obviously, if we recognise that a mistake has been made, then there's steps we have to take, and I suspect that is what practically happens most. It's usually at some point fairly obvious if something like that has happened, I expect.
Yeah. The only time it arises where something comes to light at courts.
Yeah.
So, for example, the lay client will say, well, I've actually got this massive claim for loss of earnings, which has not been pleaded, and I told Matt about it, for example. And then if you succeed on everything else, you have to advise the lay client that had that claim been made, you probably would have succeeded on it. So it is difficult. But again, solicitors owe primary duty to the court and secondary duty to the lay client. And we thought it was worth putting this in because it's surprising that sometimes you see solicitors who forget about that. That actually you've got duties of, for example, disclosure is where it comes about. So you've got an ongoing duty of disclosure. You really have to comply with those duties. It is really important. And the lay client, it may not be in the lay client's best interest, but it is something you've got to do all the same. So a really interesting question from Darius as to who the client is. Multifaceted answer, but there is a very clear hierarchy in that regard.
I think one of the other things we talked about as well was the kinds of clients that you and I can have can be very different dependent upon what day of the week it is. So for instance, and again, important for those that don't know me to get this out. So my clients are almost certainly going to be corporate companies, clients, or their insurers. I've never, to my knowledge, certainly in a personal injury case, acted for an individual. So I have no experience of that. So it's worth getting out. But again, so that's going to be different though, isn't it? I expect a litigant who is a person for a personal injury claim or whatever, compared to a company, compared to a big company with lots of resources and in-house counsel who know what's going on, compared to an insurer who might be calling the shots. So very different approaches. But actually, are their needs that different?
Well, they're all human beings, aren't they? So at the end of it all, there is a person taking a decision. And particular with some of your smaller clients, they will feel every bit as strongly about whatever the case is as an individual claimant will do, if not more strongly.
Very much so. I mean, I say I don't act for individuals, but in essence, all right, the claim might be against ABC Travel Limited, but if it's basically one person or it's their family business and it's theirs, their interest in life is running their business and doing travel and leisure things. They don't have any idea about what a Part 36 offer is, what fast track means compared to multi-track or anything like that. So you're starting very much from the base position of explaining, going through that, saying what it is, what it matters. And as you say, they will feel just as aggrieved. How dare this claim be brought against me and my company? We've done nothing wrong, etc., etc. So that's the same kind of approach. You've got to be able to get through all that and work through it properly with them in mind.
Yeah, I agree. Right, what are we going to talk about next?
We are going to talk about expectation
management. This is one of my big things, particularly with individual clients, same with corporates. But first of all, your own expectations. So you get clients who come in and you make immediate judgments about them, particularly claimants. They might be very heavily tattooed and pierced. You may have preconceptions about that. I'm more often wrong than I'm right when I've got preconceptions about things. And actually, I've reached a point where I try not to have them at all, because clients can look at a particular way. They can look very professional, very held together, and they can actually be complete basket cases, or vice versa. And also, you're right, Matt, that the client's needs are going to change over time and over the course of litigation. So you might get a client who's very keen to litigate at the beginning, but who after 3 years of being worn down by the litigation process, rather less keen to litigate by the end. What you need to do as a litigator is to try and even that out so that the client has an ability to pace themselves to deal with the litigation. So they need to have their expectations managed as well, as to how this litigation is going to go and how long it's going to take. Because they're, a very keen client who thinks, well, in 2 weeks' time, I'm going to get a trial, is very different to a client who's told, actually, it's going to be 2 years or maybe 3 years. And you need to manage that.
Yeah, and we will certainly go through that process. Again, sometimes you're working with a client that, and again, easier perhaps for me in the sense that I work with a lot of the same clients over and over. So you get to know how the individuals or how the department or the company is going to approach in a given case, but you still need to be careful because there is a saying about assuming things, but that's easier. But even so, throughout the range of our clients, we've got everything from I will fight everything to the death no matter how wrong or right it is, through to I will settle it no matter how wrong or right it is at the outset because I think that's the best thing to do with costs, and everything in the middle. Now, what happens if that's based on a particular person and their strategy on things? They leave, they go on holiday, they go on extended leave, they move around in the company, someone else comes in, you can get a completely different approach. So knowing where you are at the outset is important and what that expectation is. But it can change, as you say, and we discussed, didn't we? We won't go into the details, but recent examples of cases where clients are completely different at the end to where they were at the beginning, and it's quite easy to do.
Yeah, I think that's a really good point, actually. A change of personnel in a corporate client means that you need to then recheck whether the new person has the same priority as the other person did. Because if you start out with one person who's got a particular range of priorities, and there's a change of personnel halfway through the litigation process, which is not unusual, you're going to end up with someone who's got different priorities. And if you don't communicate with them and ask them what their priorities are, you're never going to know that. So you're not going to know what you're aiming for in terms of a win, because what this client regards as being a good outcome is going to depend on what their priority is. I've got a case on at the moment, just did a trial that you know about, Matt, where the client had a particular set of priorities, and actually Matt was involved with it at the early stages. So the client's priorities have changed over time. And actually we were talking about it at the trial last week as to what their priorities now are. And looking back over the litigation, their priorities are now completely shifted to what they were when Matt was first involved with the case. So yeah, it's a really important factor. You need to ask the client, what is a win? What do you regard as being a good outcome for you? And that brings us, I think, to the next slide. And again, it's all about communication. What do they want? What are they asking for from you? So Matt, I think we've been talking about litigation quite a lot, but this is quite important in a pre-litigation or non-litigation setting as well, which is much more your field of expertise.
Very much so. I mean, again, I would imagine, or I know that the initial conversations that we all have around new clients and new client setup and all that are very similar. But again, going around and asking peers and the rest of the team at Travlaw, where does this all fit into what you do? Kind of general feedback is, well, look, the obvious way that this works is instructions first, then advice. But sometimes it can be not quite that easy because you might have someone who doesn't understand the situation to be able to give you the instructions that you need to carry on. So it sounds a little bit perverse, doesn't it, to be kind of giving the advice before the instructions. And the truth is, it's not quite that simple. There's a little bit of everything going on. So there's that. But again, the way that we talk about things is going to be different. What do you want to achieve? Sometimes it's simple. Sometimes it's not simple. Sometimes it's contentious. Sometimes it's not contentious. So you need to be able to work around those issues and be able to kind of switch shoes or hats or whatever clothing metaphor you want to use. But the rest of it is pretty nailed on no matter what, which is everyone wants to know generally the same things. How much is it going to cost? How long is it going to take? Am I going to get what I want? Now, whether that's success in litigation one way or the other, or a drafted document which gets them where they want to be, maybe a set of T's and C's so that they can do business with consumers or with another business or something like that. They want all those things. So that doesn't change, and I wouldn't imagine it changes irrespective of the client. You're still looking at those core principles. And then, as you say, they come to us because in theory, we're experts, not in theory, we are experts in this field. But again, you need to have the confidence to let them know that they're in good hands and they will stay in good hands. And that even when things change, because again, we've all seen things where it's not so much left field, but left field from another planet, things come and hit you. And you need to be able to explain, okay, this isn't the end of the world, or maybe this is the end of the world, it changes everything. Here's how it now goes. This is the deal.
Yeah, I think that's the confidence thing is really important. They want, and actually we've got clients listening in, so I mean, tell us if you want something different to this or more than this. But clarity from us, clarity of communication, I think is really important. As you say, predictability, how long will it take, how much will it cost? Information, and knowing how often to update the client and how much information to give them, I think is really key. But the important thing about that is that they have knowledge of when you will be updating them. So I will tell you every 3 months or 6 months, whatever it might be, what is happening, or I will tell you at particular milestones what is happening. I will tell you the effect of what is coming in terms of witness statements, experts reports, things like that. All of those things and clarity of communication around those things will then feed into confidence, because the client will be confident in you because you look as if you know what you're doing. You've got a game plan, you've got a structure. But what clients want and what they need, which is what we're going to come on to now, can be two different things. So sometimes the client will need to know things that they don't want to know. So they need a dose of realism sometimes, and I'm particularly thinking of claimants here, that litigation is time consuming, it is stressful, it is going to be difficult. I have a number of cases arising out of sexual assaults, almost exclusively at hotels. I always see those clients in conference. We always go through what has happened. I think you have to see a client who's been sexually assaulted in conference because they need to know who it is who's dealing with their case. But I always tell them that this is not going to be an easy process. I will be here, your solicitor will be here, you will be supported, but you need to know when you embark on it that this is a process that takes time and is stressful and will prolong things. That doesn't mean don't do it. It means you go into it with open eyes. You know that the process is not an easy one. We need to be honest with the clients as well. I always tell those clients also that I can't get them certain things. And this comes as a surprise to clients. And actually, Matt, you probably have this with corporate clients as well, which is a little bit surprising. But in my experience, all clients need to be told that there is a limit to what we can do. And the limit to what we can do is money. That is what litigation is about. It's not about getting an apology. It's not about laying a marker down. It's not about changing in practices, unless you're talking about inquests. Actually, it's about money. That's the only thing I can get for you as a claimant. And that's the only thing you can get for a corporate entity, or limit money exposure. Sometimes you find with claimants that when you ask them what they want, they will say, I just want an apology, or I just want an acknowledgement that the tour operator has got this wrong. And I used to work for a very big tour operator, and I used to give them advice at an early stage in quite a lot of litigation. If you just accept that something has gone wrong here, it may not be your fault, it might be the hotel's fault, it might be the other supplier's fault. If you just accept that something has gone wrong here and explain to the clients what you are doing to make sure it won't go wrong again, you're going to limit your exposure. Because quite often when you're out for claimants, by the time they get to trial, they're really angry. And the reason they're really angry is that they know something's gone wrong. And whether or not the entity they're suing is actually legally liable for that, what they want is an acknowledgement that something has gone wrong. And I've lost count of the number of times that people have said to me, if they had just acknowledged that something had gone wrong, and apologized for it and explained why it went wrong, we wouldn't be here. And I've believed them, actually. So whether you act for a claimant or a defendant, I think the claimant's motivation is really, really important, because if they're that kind of claimant, if you're for a defendant, there's no downside to just apologizing. No. And it's amazing how infrequently defendants kind of get that memo.
Yeah, and I mean, look, I'm a dyed-in-the-wool defendant, so let's defendant-minded. Let's get that out there. Let's not pretend it's not true. But I agree with all of that. There are a lot of entrenched thought processes and positions across, all of the people and all of the things that we do. That's a webinar for another day. But again, we kind of talked about it in a different respect, didn't we, earlier on with the work experience. Flexibility is key, and understanding that. I mean, all right, there is an argument that if the claim form has arrived and that's the first you hear of it, you might be past the apology stage. But that's not usually the case in my experience. There is usually plenty of opportunity or plenty of engagement before lawyers get involved, need to get involved, for that to happen. Does it help? Will it smooth the way? It probably will. But again, as you say, going back to the point, yeah, there's definitely a conversation at the start of any action along the lines of, look, this is what we can expect, this is what we do. And there's almost a kind of, it's not a standard piece of text that we copy and paste in, but things that we will say about what litigation is and what you can expect. And I will usually say to people, look, type in litigation quotes into your favorite web browser and see what comes back. The quotes that come back, they're usually fairly down on the whole process and kind of recommending that you don't do it because it's not enjoyable, except in a few odd cases, some different things for different people. But it will be a drain on you. It will be a drain on your business. It will take up a lot of time and money. And it will take a long time usually. And you will, as we say, your priorities may change. So we keep coming back to that communication point, don't we, and setting the expectations, and that's going to apply no matter what.
Yeah, I think that's an important point.
As you say, motivations can change, and there's not an awful lot you can do about that. Okay. Oh, you're already chatting in chat.
Sorry, don't mind me. Chris and I are just discussing this, and Chris is making the point that when a corporate entity hands over the conduct of litigation to an insurer, the insurer is going to be much less motivated to make an apology. So there is a tension there between the corporate client and the insurer client.
Yeah. So
the insurer client is looking to minimize expense at all costs. Well, that's not true of all insurers, but as a generalization. Whereas it may be that the corporate client is much more motivated by, for example, PR considerations. They don't want to be in the news because their employee has done something wrong, for example. Exxon Keone is a really good example of that. Keone was in the news for quite a long time for all the wrong reasons. Yeah. It may be that an early apology, acknowledgement that something went wrong, and a very small sum of money would have avoided what has not been a good PR day for Keone.
Yeah, I mean, look, I've already had to say you're right about something. Don't make me say Chris is right about something like that. But he's right. You're quite right, Chris. And I know that came up in the discussions that you had about Exxon Keone on earlier episode of this series. And it's true. And again, in short, look, there has to be understanding on the other side there as well, which is what do you expect from an insurer? Don't expect them to suddenly come out with apologies at that stage, because that's not the way they're thinking. And that's not going to change, because they will see it in very different terms to how the company. Usually there is a lot of working in tandem. But again, it may reach a stage where the prevailing view is, well, is an apology actually going to change anything at this stage? Yeah. So
no, there's a point where they get so angry that it won't.
Yeah. And again, that can flow both ways. There is, no matter how the setup is and who's involved, there is usually emotion somewhere on both sides, because there is a lot riding on this in both camps, one way or the other. So again, what we need to do, and irrespective of how you're acting and who you're acting for, is to at least understand that, because that is the best way to find that place for your client to be able to at least understand what's going on and serve them well, and for them to know that you're doing a good job.
I think that brings us on to the next slide, actually, very neatly. I was talking to someone in Chambers about this, and the single piece of information that he wanted us to get across today was that sometimes the client needs to vent, and we should let them. And that's true whether they're a claimant or a witness or a defendant corporate entity. Sometimes the client feels, often they will feel very strongly, very aggrieved, as you were saying, Matt, very unhappy about being placed in this situation. And when you're taking instructions from a client, this person who was talking to me was saying, oftentimes he sees solicitors trying to close the client down, because if the client is just venting, they're not communicating information that we need. So he was saying that he often has in conferences the solicitor trying to stop the client from venting. And he actually doesn't agree with that and thinks that it's better to let the client vent, partly because it's quicker in the long run, but partly because that's part of the service that we are here to provide. We are not just information gathering. We're also supposed to be supporting the client. And it may be that allowing the client to get rid of that emotion is something that needs to happen before they go on to dealing with the actual facts, the instructions they need to give in a calmer way.
Yeah, 100%. And again, I think that across the board is true. We're all human beings. And again, these things are going to hit us in different ways. And people are going to have strong feelings, people are going to have strong emotions, come what may. There is a time and a place, granted, but I don't see why you would want to shut them down. I mean, all right, at trial, maybe not, maybe it's a bit too late, but certainly in conference and things, we need to hear this stuff. And we need to, again, if it's all about communication, it's all about developing a relationship. Why would you say stop the communication and damage the relationship?
Yeah, and I actually think, you might get a 10-minute angry burst at the beginning of a conference or at the beginning of a conversation you have with the client. After that, the client feels that you've heard them and that you're on their side. And that's really important. It's important that you and your client have a relationship where they think you're supporting them. If you try and close them down, then they feel that you're against them. So you've started that communication process in a really unfortunate way. And the other thing that I wanted to get across actually is that some clients come into this situation prepared with what they want to say. So they are leading you and they need to be able to do that. Other clients come into it needing to be led by you. So it is a very much individual-based approach that we take. I mean, Matt, I imagine that most of your corporate clients would come in wanting to lead you. But is that, maybe I'm wrong about that.
In some cases, but again, it comes down to what do they want to achieve and how do they want to do it? How much time do they want to put into it? I mean, again, I would imagine that it will ring true for most people on this call, one way or another, where the person who is your client says to you, so what should I do? And the easy answer to that is, well, that's not how it works. We take the instructions from you, but it's more of a collaboration than that. So again, understanding what they've said, why they've said it, and what their motivations are is highly important. And then you can have the conversation of, it's usually a case of, well, look, if you want to win at trial as a claimant, then we're almost certainly going to have to do this, this, and this. So therefore, I'm going to need this, this, and this from you. Witness statement, evidence, all the stuff that, we would usually get. And then, we can review and look at it. But right now, here's where we're at. And again, this is the same time as you have the conversation you mentioned earlier, Sarah, which is, this is what we can achieve. Again, I've seen that. I've seen, I'm going to get from your client an apology from the judge in court. And it's like, no, you're not. I don't say that, but I'm thinking that. No, you're not, because they can't do that. Even if they wanted to, they can't. It's all about money, except in some very specific circumstances. But, so it's joining all those things up together. And taking instructions is what we do, isn't it? If this webinar is all about how do we get the best from our clients, then understanding how we take instructions and how they give instructions is crucial.
Yeah, that brings us on to the next one, I think, actually, in relation to giving advice. Yeah. So when you're all of this communication is a two-way street, right? So we're giving advice, we're taking instructions at the same time. Now, we were talking about giving advice which is welcome, which is something that clients will be very open to. Where it gets a bit trickier is giving advice which is unwelcome. And some clients will do the metaphorical thing of putting their hands over their ears and going, la, 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 I can't hear you. So when you appear to be approaching the unwelcome advice, they will just stop listening to you. And I think you need to be, or we all need to be, very clear that we are getting that advice across, that we have ensured that that unwelcome advice has gone in. And I think, Matt, really the only way of doing that is to give the unwelcome advice and then get them to repeat it back to you. So, it's things like, I think we've got a really difficult case here. The client is hearing, okay, so we've got a case. So they're missing out the words that they don't want to hear. So you need to get them to repeat it back to you so that you're sure that they've actually got what you're telling them. And I think a lot of people are very unwilling to give advice in terms of percentages. And the single biggest thing that you get asked all the time as a barrister is, can you tell me what the percentage prospects of success are? Now, if I say the percentage prospect of success is 70%, we're never actually going to find out whether I'm right about that. So it doesn't hold a fear for me to say that. I do think 7 out of 10 judges are going to find in your favour. We're never going to run this case in front of 10 judges, so we're never going to know whether that's right or not. But that's roughly what I think it is. So don't be afraid, I think, to give a percentage prospect of success, because people understand percentages. But that said, everyone gets, and everyone here who's instructed me will have heard the out of 10 judges, at least to a mad speech. So whenever I'm advising in conference, it's always, I'm never going to give you more than 80% prospect of success, because 2 out of 10 judges are going to do something completely unexpected. So you can never guarantee anything. Yeah. But you need to be aware that when you're talking to clients, they tend to hear what they want to hear. So if you're, I don't know, drafting a schedule of special damage for a claimant, the claimant looks at the figure at the bottom of the schedule and goes, I'm going to get £1 million because that's what we're claiming. Similarly, if you're doing the counter schedule for a defendant, they look at the figure at the bottom and say, £10,000, that's the worst case scenario. So again, clarity is needed on, this is just a document that goes to the court. You're not going to get £1 million, but this is what we're claiming. Yeah. Or the converse of that, which is that the claim's worth X sum of money. The claim's worth £300,000, but we've put in this counter schedule because this is what we do. And again, it's just communication all the way along, isn't it?
Yeah, and human nature being what it is, it's much easier to give lovely, positive, fantastic advice or good news than it is the opposite. And we see this, don't we? This is getting back onto the how to instruct your barrister thing, but it's like, so, you have counsel on a case and you're not there. It might be a small claims case or something like that. So the case is going to finish at 12 midday, and then time goes on and you're like, this has gone bad, because they'd be straight on the phone if they'd won. But yeah. You don't, but there are other things as well. But yes, an affirmation of the advice that you've given is important, because again, let's look at this realistically. When things do go wrong, and we talked about this, touched on this earlier, the powers that be, the third party reviewing this whole case, is going to say, well, where did you give that advice? Did you take a file note? Is there an email? And you're going to feel daft, and you're going to look daft, and you're going to be in a bad place if there isn't that kind of thing, because the client may turn around and say, well, I didn't understand. So, again, it's a sensible process to go through just to make sure that they understand, they understand, and it's recorded that they understand, irrespective of whether it's good, bad, or otherwise. On the percentage thing, I totally agree. Here's the thing, right? So if I'm saying to a client, maybe me and you are on a case, Sarah. I'm saying to the client, well, it's difficult to say, litigation risk. It could be a 50-50, it's kind of, I don't really know. And put the phone down, ring you and say, this is a winner, right? This is 70, 80. It's like, if I know it's 70, 80%, or I know it's 20, 30%, or 10%, if it's either extreme, we're never having that conversation, probably, or it's easier to have if it's positive. But I always think, look, if you can turn to the person next to you in the office or in chambers or whatever and say, yeah, this is a good case, we've got strong prospects on this, 75 plus whatever, why can't you say that to your client? What are you worried about?
Yeah, for sure. Now we have a question about this. How do you clarify what is and is not covered by your advice, Carna Meadows, without being annoying to the client? So effectively, this is to do with communicating again to the clients. This is what my advice covers. I don't think clients find that annoying, actually. I think you just, this sounds really simplistic, you just do it. You just say to the client, I am going to give you advice. It covers X. And again, because of Kahn and Meadows, you really want that in writing, as Matt says, as a defensive measure. You know, I am going to advise you about this thing. If you want me to advise you about something else, then tell me you want that alternative advice. But it is just a question of clarity. It's clarity. Yeah. What do you want advice about? Okay, this is what I think you want advice about, and this is the advice I'm going to give you about it. And these are the demarcation points.
Yeah, I mean, look, I will defer to anyone who has more knowledge on this than me, which is likely to be a lot of people. It's, for those that don't know, it's a Clindeg case. I think it's the kind of case that every lawyer should read and be aware of, but it's not the kind of thing that you should be awake at night worrying about. But it's all about the scope of advice. And ultimately, you're going to say, as you just said, Sarah, this is what I'm going to do for you in this particular case. This is what we're doing. This is how we're acting. Mm-hmm. But I think the question in Cannes comes up, well, when a client turns around and says, yeah, but you're supposed to be the expert. How come you didn't tell me there was a chance of this? Of, I don't know, a Part 20 claim from another party or a counterclaim or something like that. And, you know, it's difficult sometimes to turn around and say, well, you know, you never asked us that. You didn't, you know, put that as on the table as an issue. So it's the balance of how far do you go in terms of saying, this is the landscape, this is what could happen, this is what might happen. And going back to an earlier slide, a point I meant to make was one of the difficulties we come up against with our corporate clients is, and you soon learn, is have you got the kind of client who wants an in-depth advice full of detail with everything covered and will be unhappy if you don't? Or have you got the kind of client where you prepare that and they say, yes. I don't have time for 40 pages of advice. Just tell me if I'm going to win or not. And all right, those are, again, our extremes. But again, what client wants, client gets usually. If they want a shorter advice, just give me the key points. But again, you've got to be careful because then you fall into the trap of them turning around later on and saying, well, you didn't tell me about X. And that's where a lot of lawyers get caught up in the 50-page advice. That's wrong as well. Yeah. So balance.
I think ask them what they want. You know, do you want 40 pages of advice that tells you everything, or do you just want the key bullet points on what is likely to happen? But it's communication again.
Yeah, communication.
Okay, let's go on to the next slide.
Yes. So I don't know if we've kind of covered a lot of this actually.
Yeah, I mean, I think it's to do with keeping informed, which is what we were talking about earlier. When can they expect to hear from you? Tell them, even if nothing happens. So if, and actually you get a lot of unhappiness with clients, both claimants and defendants, who don't know what's going on and who say, well, you told me you would update me every 3 months, whatever it is. And you have to send out those letters that say the costs that are being incurred and so on and so forth. And at the same time as you do that, do a two-way communication. Just, here are the costs that are being incurred. This is what's happened since last time. This is what's happening now. Tell me what's happening in your world as well. Because actually, that example of the missing off ahead of loss is not as uncommon as it should be. So people, you know, I've had clients die and we haven't known. It's quite important to find that stuff out. So if you are, it's not just sending letters into a void. You know, these are the costs and you just send that letter off and you don't worry about it. It is really important to send a letter off that says, these are the costs, this is what's happening. What is happening with you? Are you still alive? Really basically. Have you still got your job? What is happening with your treatment? If it's a claimant, if it's a defendant firm, have we got any more documents? Has something come to light? And actually that's the next slide, I think, is to do with, you know, informing the client immediately of important things that are going on. Now, Matt, we talked about this in advance in relation to mistakes. And I know we've spoken about mistakes already today, so it sounds as if everyone's making lots of mistakes. They're not, but everyone makes mistakes from time to time. We have all made mistakes from time to time. And the single most important thing really from today is that you've got to cough to them. Because otherwise you're going to be up before your regulatory body. And every so often, every few months, you get some unfortunate paralegal or newly qualified who is up before the regulatory body because they've made a mistake. It's not the mistake that's the problem, it's the cover up, always, always. And actually most clients are pretty understanding if you've got yourself into a pickle. And I mean, I worked for a paralegal for a year after bar school. And on my first day, our managing partner took me in and said, look, you will make mistakes this year. There's almost nothing that we can't solve, but you have to tell us. And I thought that really was really helpful and good advice. And it's advice that I give every pupil. There will come a time where you mess something up. Just tell me. I need to know. Just tell me. We'll sort it out together. It's no problem.
Yeah. And we do the same thing with our, I mean, it's not just new starters or people, new entrants into the firm. It's a message we reaffirm, which is you will never, ever be in trouble, or there won't be an issue in that sense if you make a mistake. If you don't say anything or do anything, that's where, you know, we'll be unhappy. Yeah. Because as you say, there's nothing that we can't fix. And, you know, there's different ways that can go. And the severity of the issue is obviously a factor. But actually, usually there's ways and means to get this around. And we also tell people, and again, this is difficult because we're going off into a litigation thing now, but, you know, you see the other side make mistakes. And then there's that whole set of case law about, do you have to say anything? Do you have an obligation? Can you just keep stum, et cetera, et cetera? Well, it's like, these are people that you might be working with. So, you know, be a little bit understanding, put yourself in their position. You don't have to compromise your client's interests. But again, we see people, you know, or we've come across cases where mistakes are kind of absolutely jumped on and pounded on. And lots of people say that's exactly right. And probably it is. But it's like, well, at least have understanding that someone there is, as you say, losing their job, in trouble, potentially up against a regulatory hearing, et cetera, et cetera. So it might be you one day. How would you feel? And even if you're 99.9% an amazing lawyer who never makes mistakes, which is a passing grade in most aspects of life, there's a case coming up with your name on it. Yeah.
Yeah. No, I'm afraid that's true. It really is there, but for the grace of God. Let's move on from this topic, Matt. So it's not a happy topic. Yeah, this is to do with keeping informed. And Matt, this is probably one for you more than me, to do with disclosure. We've spoken about the ongoing duty of disclosure before, but how do you get disclosure from your client? Because particularly with corporate defendant clients, you quite often don't quite get the disclosure you need. And it often happens that, you know, when the trial is listed and the witness knows they're coming to trial, they start producing great sheaths of documents. And that's happened to me more times than I would care to say. How do we avoid that? How can we get the disclosure that we need from the client?
Well, if there's a way to completely avoid it, we haven't found it yet, despite trying, because, you know, again, in the initial conversations and the kind of, look, what's going to happen? And there's, again, taking a step back at the outset of, say, litigation, it's probably more relevant litigation than it is to the non-contentious stuff. Why can't you put together this is what's going to happen in this case? Because you pretty much can predict it, you know, including kind of like timescales, and it will change, but you can kind of do it. And one of the main flags there is disclosure. So you need to be thinking about this now, because this is the first time we've spoken, or, you know, kind of we spoke the other day and here we are. So documents will get lost, they'll get binned, they'll get shredded, they'll get recycled, they'll be forgotten about, they'll be in some kind of, you know, filing cabinet somewhere. So get them together now, have them, and let's see them, because we need to know, you know, from a point of view of what we've got, that's that. And bear in mind, you know, there is this thing called disclosure. We explain what it is. We explain all the things that often get forgotten about, which is, by the way, there will have to be a disclosure statement made that says, this is what I've got, this is what I haven't got, this is what I used to have. And I can't sign it. Sarah can't sign it. You're the one signing it, or someone from the company. So, like, really important, because if it turns out to not be correct, it's issues. So that often helps focus the mind. But even despite that, as you say, to our horror, often later down the line, as minds get particularly focused coming to trial, it can happen. I think it's a lot rarer than it used to be, in fairness. But I know we all see it. So again, but it's part of that. Look, we're going to say it again. We're going to say it lots and lots of times. The communication between us and the clients. This is what's going to happen. This is what you can expect. This is what we're going to need. This is what we need from you. And then if you get the disclosure back, you look at it and go, evidence. He was guilty after all. That man went to the chair 4 years ago. We need to see it sooner rather than later.
Yeah. Same with witnesses, I think. And I always like in conference to close off such witnesses there may be. And that's, again, it's communicating in an early stage, isn't it, really?
Yeah, 100%. Because again, we're getting into litigation specific stuff. Usually both sides know exactly who the key people are and who should be involved. And you need to work that out. And you need to work out, again, are they still around? Have they disappeared without a trace? Are they still in the employ of companies, in our case, or can we get a hold of them? And explain to them as well that this is how it is probably going to go, and this is what may be needed from you. This is what we need now. Because actually, we tend to find, don't we, most people are happy to write statements as they remember it at the time. They're happy to engage with the process. Not so happy to go up to Newcastle County Court for 5 days next August.
Yeah.
So all that needs to be spelled out, all that needs to be told. And again, making that point, which is something we made at the start, which is a lot of this is nearly always, in fact, for the benefit of the courts, not for us. You're not helping us, you're helping the courts. So bear that in mind when it comes to things like saying, well, I'm on holiday in August, I can't come. It's like, well, that's not what you said at the time. So setting all that up so that everybody's on the same page.
Okay, what are we talking about next?
Next, we have providing a full service. And this is where me and you thought we were hacking each other's emails because what we said was almost the same thing, spookily so.
Yeah, I mean, I think we're not just lawyers, actually. We're kind of an entire support team, whether it's claimants or defendants, actually. And more obviously with claimants because they're an individual and they may have suffered a catastrophic injury, for example. They may have had a life-changing event. We forget that. We also forget that for defendants, it's life-changing. If you're a small tour operator and you're sued by someone who's got a catastrophic injury and for one reason or another you're not insured, this could be it. This could be the end for the company. And that is enormously stressful for, whoever it is, whether it's claimants, witnesses, defendants. And, we breeze in, we're used to going to court. We do this litigation stuff all the time. They are one of a number of cases that we have. And it's very easy to forget that actually you're dealing with people who are in need of support. And every client needs a degree of support. Some cases require more than others. Sexual assault cases, again, the claimant may need someone to sit with them throughout the trial. They may need a professional to sit with them throughout the trial. That's fine, and that's something that you can facilitate. But you get quite a lot of claimants who struggle and just try and struggle through because they're afraid to ask or they don't know that help's available or wherever it may be. But it's just a question of retaining a bit of humanity that, I know we're lawyers and this is what we do. It's scary for everyone else. We just assume that, everyone's fine with giving evidence. They just go off and do it. But actually, they need a bit of support. And the same is true for us as well. When you have, for example, I had a rash of inquests a while ago. And if you have back-to-back inquests, inquests for some reason are much more like this than other cases. You absorb the emotion, whoever you're acting for. You absorb the intensity of it, and actually you need to decompress in some way. And it's probably not healthy to just do that through gin. It's probably healthy to do it through some form of other support, whether it's your peers. And that's the beauty actually of working in a solicitor's firm, that you do have that support. And it's really important to ask for it. There's no shame in asking for it.
No, absolutely. And harking back to what we said a few slides ago about, making mistakes and the poor paralegal. So it tends to be, doesn't it? Rightly or wrongly. Litigation in particular is a team sport. It's a team game. And if you have people that you can reach out to and rely on and kind of like absorb the bad stuff that's going on between you, that will be a help. And often, you find in those paralegal cases where they were on their own, basically left to their own devices without that kind of support. And then that extends to, when you've got a team of people in litigation, you're going to have the client, you're going to have the solicitor or solicitors, you're going to have counsel or what's the plural of counsels? Counsel.
Doesn't feel like counsels, does it? I think it's counsel, like sheep.
Counsai. Anyway, you're all going to be relying on each other, and that's a way to help with that, but it's not going to completely fix it, because again, we've all been at trials where the emotion is, you can cut through it. And there's plenty of stuff that's not even trial based where you get the same thing. JSMs, mediations, those things can take you down in terms of the emotional side of things. And we deal with all of that, and we do it because it's our job, and we do it because we want to, and because we enjoy it, hopefully to a degree, in the sense that that you're doing this for a reason, one way or the other. And justice is being done, and the outcome is not the justice. The justice is the process. But yeah, no one can do that on their own. The client can't do it on their own. That's why they've come to us. We can't do it on their own. That's why we have the support of counsel and anyone else who's involved in the case, witnesses, etc., etc. So we do end up doing all of that. And it's back to the venting thing. That's an early part of this, isn't it? The full service.
Yeah. Are we on to questions now?
I think we are.
We are. So we had a couple of questions before the webinar. And this one, how do you deal with a client who knows much more than you? This is actually a question from a professional client of mine who actually knows more about his area than pretty much anyone else does. So I find it difficult to believe that he'd have a client who knew more than he did. But it is quite an interesting question. You sometimes get clients, well, first of all, you get clients who think they know more than you do because they've looked up how much their claim is worth on Google, or because someone down the pub told them what the law is. Sometimes you get clients who actually do know more than you do because they might be a corporate client who knows more about this specific area than you, or they might be a client who's legally trained. And one of the best lawyers I ever met was actually on a Travlaw case, and it was the legal counsel for Balkan Holidays at the time. And he was an incredibly good lawyer. How do you deal with a client who knows more than you? The ones who genuinely know more than you, brilliant. You've now got someone on your team who is even better than you are, and that is a great asset. The clients who think they know more than you but don't, slightly more difficult. And actually, this is where the inspiring confidence thing comes in, that you have to have said from the beginning, look, I know what I'm doing. This is what I do. You've looked this up on the internet, and I'm sure that you've got an answer that's very interesting, but actually it's not a substitute for doing a law degree, doing a bar course, and the best part of a quarter of a century of experience. And although it might say that on the internet, although that might be accurate in some cases, in your case, it isn't, and this is why. So a client who knows more than you, there's no reason to be defensive about that. That's good news if you've got a client who knows more than you, because you can learn from them. A client who thinks they know more than you is a slightly different proposition. Do you get that a lot, Matt?
To a degree. Not very often, if I'm being honest. I mean, again, trying to put all kind of arrogance and whatnot aside. So we sell ourselves as being experts in this particular field. Yeah. And we'll just as quickly say, no, I don't know anything about housing repair claims, so don't come to me.
Yeah.
So hopefully they're coming to us, and again, it's a reputational thing. So if they think that we're giving it a lot of chat and we don't know what we're talking about, they won't be with us very long, and that, to my knowledge, has never happened. However, as you say, there are plenty of people who will know far more about us than the subject matter, because that's their world, that's their game. And as you say, what a great problem to have. Is it a problem at all? It probably isn't. It's great. And so you can say to them, great, well, I will never know about this particular part of the world and the specialist tour operation that you run in it. I just won't, with all the will in the world. However, you do, and so let's get that into witness statements. Let's get the background, what's relevant. We can sort the wheat from the chaff. That's great. We get plenty of clients who are good on civil procedure and litigation and whatnot, and they may it's happened. Have you thought about what about CPR? Trying to think where we're up to 298.7. It's like, no, I haven't. Let's have a look at that. No, that's not relevant. Or actually, that's a good shout. Okay, fine. I'd rather be us on the right track and just have, not covered something off. It doesn't really happen like that. So that's what I say to that. I think good. Again, as long as we're a team, as long as we're on the same page, that's not a problem.
Yeah. Teamwork and communication again. And something which cuts across teamwork and communication. Are clients complaining more with or without foundation? Well, of course, my clients never complain, but I actually don't detect that. I don't detect that at all.
I don't.
I don't know what others think on the call.
It could be different things to different people. And so, as you said, it's looking down the list of attendees today, there's plenty of people who are going to have views on this one way or the other. I don't get that sense. I know we talk about, the whole complaint culture, and does that transfer to our world and stuff like that? But again, I think from my point of view, I've got clients who are advanced in the sense that they know what they want. They're usually, in one sense or form, professional business people who will tell you if they think that you are not doing it right or they're not happy with how it's gone. A lot of it is in the setup. Again, if you say to a client, you're definitely going to win this, then rightly or wrongly, you're asking for it at the end.
Yeah, you are.
But no, I don't get the sense that there's more of it going along. And again, I'm not going to lie, it's happened. I'm not going to lie, it's never been that big, but it has happened. And often there's some level of justification in it. Okay, on review, that could have gone better, or we should have done this, should have done that. It's a learning process. What can we do?
But part of it is expectation management as well, because if you've managed the client's expectations, they shouldn't be complaining even if something goes wrong. Sometimes things do, but I don't detect that either. I see sort of nothing on the chat saying that there's any view either way. So I suspect the answer is no, they're not complaining more. I don't think so.
It's an emotive issue that people would speak out on if they thought otherwise. I think it's nevertheless, it is, you don't want to be spending your entire time watching your back, but it is something to be mindful of.
Yeah. Right, and then I think, unless there are any other questions, we've run out of time, and it just remains for us to tell you. Otherwise, again, Em will be very cross with me if I don't tell you what's happening next week, which is that John Bryant and Zach Bradamere will be talking about trusts resulting in constructive, a subject about which I know absolutely nothing, it has to be said, although I did it in my earlier days. But any questions, feel free to ask them now. Otherwise, we'll say have a good afternoon to you. Thank you for coming. May see you next week on the trust thing, where I'll be asking lots of very foolish questions, no doubt. But thank you, Matt, for coming. That was really, really helpful.